Introduction. All right, we got our recording in progress memo or message, and we're now ready to begin. So for those of you who don't know me or haven't been on one of these calls, my name is Patrick McQueen. I'm a real estate attorney here in Arizona. I've been doing this for 20 years, and I deal with all of the issues that we're going to talk about today. What we're largely going to focus on today are ways in which you can enforce a commercial real estate contract. And there are a number of ways. There are a number of different types of contracts. We're going to go through all of that stuff. And if you need any of the stuff that I'm mentioning today, if you want an outline, if you want any notices that we're going to talk about, if you want any sample forms that we're going to talk about, just shoot me an email after this session. Be happy to get it to you. I'll put my contact information in the chat, but you can kind of contextualize some of the stuff that we're talking about if you take a look at these forms and the notices and what have you there. So in any event, again, Patrick McQueen, real estate attorney here. Before I get into enforcing commercial real estate contracts, which is what we're largely going to focus on, I do always give updates on what it is that we're seeing, what it is that is crossing my desk right now. And I will tell you, number one, we've seen an uptick in calls regarding foreclosures, loan workouts, both on the residential and on the commercial side. So mostly those are in kind of unique situations where there was maybe seller carry financing or somebody overpaid in the last 6 months, or some just want to understand, hey, if things start slowing down, what are my rights? I want to be prepared. I want to understand what I can do. And so we've seen an uptick in those calls. Second area in which we've seen an uptick in calls deal with this Calway decision, K-A-L-W-A-Y. Okay, we're receiving a lot of questions on the applicability of this new law that came to be from the Arizona Supreme Court. So we got a new law dealing largely with HOAs and CC&Rs and amendments. And the way in which this affects people largely is in the area of short-term rentals. So if any of you are doing short-term rentals, or if you're helping people buy for short-term rentals, this is the new decision that is going to affect us all, or it's already beginning to affect us all. Under this new decision, if an HOA wants to amend their CC&Rs, which happens all the time, let's say they want to amend their CC&Rs to prohibit short-term rentals or to restrict them, they've got to now have a 100% vote, or that amendment. So everybody it has to be unanimous. Everybody in the community has to agree to it, or the amendment must, at the very least, have some other reference to it in the original CC&Rs. Okay, so if you're trying to modify something pertaining to short-term rentals, well, the original CC&Rs have to address short-term rentals in the first place before it can be amended. So this is a huge case, deals with all sorts of homeowner association issues, deals with short-term rental issues. And so if you need a copy of this decision, chances are you've probably already heard of it. But if you need a copy of the decision, let me know. Happy to get that to you guys. Okay. The third area in which we're receiving a lot of calls deals with these new wholesaling laws, or real estate investor laws. Governor Ducey signed a new law at the end of May. And if you are a wholesaler, okay, the law now requires you to disclose that you're a wholesaler to the person from whom you are buying. Okay, so if you're buying a property, usually from a distressed seller, you now have a legal obligation to disclose to that distressed seller that you're a wholesaler. Okay, you also have to now disclose to your end buyer, maybe it's a fixer, maybe it's a flipper, maybe it's another investor, that you're a wholesaler as well, and that you may not have legal title to your property. Okay, so those two disclosures now must be made. If you want a memo on this subject, if you want proposed disclosure language, I'm happy to get that to you. Looks like Sylvia wants. Sylvia, what would you like? Did you send that pertaining to a copy of the decision or the wholesaler stuff? Either one. It sounds like she wants a copy of the decision. Okay, perfect. Well, I'm happy to get that to you, or I can send it to Isabel at WeServe, and she can distribute them, whatever's easiest for everybody. But those are the three things. We've seen an uptick in short sale foreclosure, kind of loan workout stuff, both on the residential and on the commercial side. We've seen a lot of calls pertaining to Calway, particularly as it pertains to short-term rentals. And then, of course, we get these questions from investors all the time about, what can I do in terms of wholesaling? What do I now have to disclose? If you need that information, just let me know, and I'll put my information in the chat before we go. But it looks like a couple of people have already reached out and are asking for that. Now, one of the most common calls we get deals with enforcing contracts. What can I do? What are my rights? And in Arizona, if you remember this, in the commercial setting, okay, we're talking about commercial enforcement here, commercial contracts. The courts usually prefer to follow the contract. And so if you've got a lot of remedies listed in your commercial contract, in your purchase and sale agreement, in your lease agreement, in your loan documents, then courts are largely going to follow those. In the residential context, it's a much different story. In the residential context, we have statutes that the courts are going to, say trumps what the contract says. So in a residential deed of trust, for example, the way in which a lender can enforce that is really just statutory. They can only enforce it to the extent that the law under our consumer protection statutes and the law under our trustee sale statutes works. On the commercial side, if you have a loan agreement with a lender, the court is going to say, well, I don't really care what the statutes look like. What did the parties agree to? So you have to keep that distinction in mind. So in the commercial context, courts are much more willing to agree that the parties can contract the way in which they want to. In the residential context, very, very statutory driven. Okay. And what we're going to talk about today are three types of commercial contracts and the ways people and the remedies that people can use to enforce them. Okay, we're going to talk about purchase and sale agreements, just a regular, if I want to purchase a building, if I want to purchase raw land, whatever it is, if I want to purchase something for a commercial purpose, we're going to talk about that. So purchase and sale agreement, we're going to talk about how to enforce those. We're going to talk about loan documents or deeds of trust, promissory notes and guarantees. And then we're going to talk about leases and the way in which you can enforce a lease, commercial lease. Now, we'll first talking about purchase and sale agreements. Okay, what are our seller's remedies in connection with a purchase agreement? So if my buyer breaches, if we have a purchase and sale agreement to purchase a building, and the buyer breaches, okay, buyer says I'm not paying, or the buyer violates a confidentiality issue or clause, the buyer improperly cancels. The buyer breaches a representation and warranty that's put into that contract. What are the seller's remedies? Well, usually the obvious one is to keep the earnest money. So if the buyer is in breach, if the buyer cancels too late, if the buyer just says, I don't want to do this deal anymore, and it's after the inspection period, the most obvious thing to do is to keep the earnest money. Well, you can also put into your contract, and the courts will allow, is to keep the earnest money and sue for additional damages. Okay, so that doesn't always get put into the contracts, but courts will enforce that. So if you're representing a seller and you want to beef up the remedies, well, certainly keeping the earnest money is one of the remedies, but keeping the earnest money and suing for additional damages, that's also an option. The other option is that the seller can waive the earnest money and just sue for damages. And in some instances, sellers can actually sue a buyer for specific performance. They can force the buyer to proceed. Okay, so there are a number of remedies. Again, keeping the earnest money is a remedy. That's one way you enforce the contract. Keeping the earnest money and suing for additional damages, that's another way. Waiving the earnest money and suing for damages, or seeking specific performance in some instances. Okay, and when we're talking about damages, so again, we're talking about a situation in which the buyer breaches, in which the buyer says, I'm not going to move forward, or it has some other type of breach of the contract. What we're talking about are ways that the seller can enforce this. When it comes to damages, let's think about those types of damages that a seller may incur. I'm selling my commercial space. I had a bunch of leases in place. This buyer breaches. What are my damages? Well, my carry costs. I've now got to pay another couple of months of rent or a couple of months of my loan payments. I may lose profits. I may lose the ability to make a profit on the sale. And certainly the difference between what I had this contract with this particular buyer for and a subsequent buyer. If I had the building for sale to this first buyer for $1 million, and now I can only sell the property for $900,000 to another buyer, that's $100,000 in easy to prove damages. Okay. And so again, what we're talking about are seller remedies for a buyer breach. There are a number of remedies. Most people just think of the earnest money. They just say, well, just give me the earnest money. Well, there are actually a number of situations in which you can seek more, and it has to be written into the contract. If you're going to seek more than just the earnest money, courts will allow it, but it must be put into the contract. So that's an opportunity for you as agents to beef up some of the remedies section if that's what your seller seeks. If you've got a buyer that may be wishy-washy, you may want to hold their feet to the fire and seek all 4 of those remedies, or the option to seek all 4 of those remedies if there's a breach. Okay, so seller remedies for buyer breach. Again, there's about 4 of those things that you can do, and usually you see a buyer breach when there's an improper cancellation, when there's a cancellation after the inspection period, and you know, as a seller, you're going to want to keep all of this information handy. You're going to want to write out everything that you've incurred, all of the carry costs. Maybe there's an association that you're a member of that you have to continue paying, broker fees, additional broker fees, that sort of things. Those need to be included in your contract if you want them enforceable. If you want the ability for your seller to be able to recoup these things, that needs to be in the contract. Now, before you're able to collect any of these things, right? Before you're able to keep the earnest money, before you're able to sue for lost profits or the loss on the sale, before you're able to sue a buyer for specific performance, we've got to look at a couple of other parts of the contract before we can do those things, okay? In most instances, you must usually provide notice and an opportunity to cure before you can even consider keeping the earnest money, before you can even consider suing for damages, before you can even consider specific performance claim. We've got to look at the type of notice that's required. When we're doing that, we look at the contract, okay? You've got to provide proper notice, all right? Make sure it's timely, right? Under the contract, it's going to tell you when this notice needs to be served, and make sure you follow the contract to a T. If you're going to be providing notice and you send out an email, when the notice provision in your contract says that everything must be provided by fax or certified mail, that's an invalid notice. Courts will not allow it, okay? So in the residential context, that may be a completely different story, but in the commercial context, you must follow the notice provision to a T, okay? You must also provide usually an opportunity to cure. And in your document, in your contract, there's going to be an opportunity to cure, a cure period. Sometimes it's 3 days, sometimes it's 5 days, 10 days, 30 days, whatever it may be. You've got to follow those things before you can go and do any of these enforcement actions, okay? So then we look as well, we first look to see, you know, what are my damages? What can I collect? What are my remedies here, okay? And again, the remedies being keeping the earnest money, suing for damages, suing for specific performance. Then we look at the notice and the right to cure, right? We have to provide adequate notice. We have to provide proper notice. If our notice isn't proper under the contract, the notice is invalid, okay? The courts will kick out the case. It's done. You can't do anything else. You have to continue with the contract, which is a scary proposition. So we look at our notice and cure period, and then let's assume that the buyer still isn't curing. Well, then we look at, you know, what our options are next. If there's no cure, there's mediation, there may be an arbitration, or there may be litigation. Those are really the 3 options, okay? And those are usually going to be spelled out. Mediation involves a third-party mediator and sort of a splitting of the baby, where you might not get everything you want, you might not get the full earnest money, but you get to move on. Arbitration, on the other hand, is an all or nothing scenario. It's one person wins, one person loses. Whereas mediation is sort of, we're splitting the baby. Both parties are basically going to leave unhappy, but they're going to get something, they're going to be done. Well, in arbitration, one party is going to be very happy, and one party is going to be very unhappy. It's like court, okay? There's a winner and a loser, or you go to litigation, okay? So those are the steps that I look at. Number 1, I look at what are my remedies. Number 2, I look at what are my obligations to notify the other party, and how do I need to do that? And then I look at what happens if there's a continuing breach. Do I have to go to mediation? Do I have to go to arbitration? Do I have to go to litigation? And all of these things should be included in your contract. They're all in the standard form, AAR contracts, they're in the AIR contracts, but you can beef them up, and courts will allow you to beef them up. So if you've got somebody who's out there who's a little wishy-washy, that you don't really trust on the buyer side, well, then start beefing up some of these remedies. And if you need some proposed language to help you put this in a little bit more context, shoot me an email. I'll get you all of this stuff so that you're not just shooting in the dark as to how this stuff sounds. Okay, those are the seller remedies for a buyer breach, right? If we look at the contract, these are the typical ones. This is what needs to happen. Okay, let's talk now about buyer remedies if there's a seller breach. Okay, if we're representing a buyer who's buying a commercial building and the seller breaches the contract, there's really two options in this situation, and that's it. Okay, there's really two options. You can sue for damages. You can try to collect damages. Okay, and the damages are going to be, well, I put X amount of dollars into doing my due diligence. I put X amount of dollars into this survey. I put into buying a survey. I put X amount of dollars into these attorney's fees. I put X amount of dollars into this environmental study, whatever it may be. Those are some damages. And now I have to find an alternative building that is similar to the one that I was going to buy. And what if I have to pay more for it? What if I have to pay $100,000 more for it? Well, that's my damages, right? So it's the money you put in to try to purchase the property, and it's the difference between what you are under contract for and what a similar building is going to go for. And so those damages could be significant. So again, first option, if I'm a buyer and my seller breaches, is to sue for damages or to seek to collect damages. And the damages are going to be what I tried to put in, or what if I've tried to find alternative, or now that I have to find alternative place, what is that extra amount going to cost me? Okay, so it could be significant. All right, and that's it. Those are really the only remedies that make any sense for a buyer. Of course, you want to seek attorney's fees and those types of things, which we'll talk about in a second. But those are the two categories of things that you can do, or sue for damages or sue for specific performance. Okay, so suing for damages, suing for specific performance, really the only two things that the buyers can do. When you sue for specific performance, when you're going after a court order that says this seller must now sell, all right, it's a lawsuit, and you separately record what's called a notice of lis pendens. Okay, so again, we're talking about a situation in which the seller is saying, I'm not selling to you anymore. What is my buyer's remedies? The first is damages. The second is to sue for specific performance. Specific performance is a court order obligating the seller to sell. And if the seller still doesn't sell, the judge will actually sign the deed. Okay, but if you're going after specific performance, you need to record what's called a notice of lis pendens, a notice of pending litigation. That puts any other buyer out there on notice that they're going to take subject to your first right of the property, to your first right, that there is a property dispute here, all right? And so that's a powerful, powerful document, okay? So again, we're suing for specific performance or we're suing for damages. If we're suing for specific performance, we absolutely need to record that notice of lis pendens, because that's the document that stops the seller from selling to a different buyer, okay? Once a breach or potential breach has been identified, we take the same steps that we would have taken as is what the seller could do if the buyer was breaching. Okay, we have to provide notice, right? We have to follow the notice provision in the contract. So we're going to follow the contract, whatever the notice provision says. Facsimiles aren't good, but certified mail is good, or postal service is good, and emails aren't, or emails are fine. Whatever it is, you have to look at the notice provision. You have to give the opportunity to cure. So we're looking at the cure provision. Again, we're going to follow the contract, see what's in the cure period. We have to give them a certain amount of time, perhaps. And then the next step again is mediation, arbitration, or litigation. Now, even though there's a mediation provision in your contract, or you have one in whatever contract you're using, and even if there is an arbitration provision in your contract that says you have to go through mediation or arbitration first, in a situation involving a seller who is refusing to sell, you can ignore those. You can ignore the mediation. You can ignore the arbitration. You can go straight to litigation, because the risk is that the seller is out there selling to somebody else. Okay, so if I'm a buyer, or we're representing a buyer, and the seller is refusing to sell, even though I've got a mediation provision in my contract, even though I've got an arbitration obligation in my contract, I'm going straight to litigation because my concern is that the seller is selling to somebody else. Okay, so just keep that in mind in a situation in which you represent the buyer and the seller is refusing to sell. Okay, that's it. That's how purchase and sale agreements work. Again, we look at the contract to see what our remedies are. The remedies are going to either be damages or some form of specific performance. We look at the cure obligations, the obligations that or the rights they have to cure their default. We look at the notice provision, and then we look at what steps we can take next. So it's a 3 or 4 step process to finally get through and enforce your rights if we're talking about a commercial real estate purchase and sale agreement. Now, this doesn't include post-closing situations. So let's say that, you know, you buy this building, or your client buys a building, and there were undisclosed issues about the air conditioning unit. There were undisclosed issues about the roof, whatever it may be, some of the bigger structural issues. Well, it's the same thing. We've got to follow those sort of obligations that are outlined in our contract. And so, you know, what we're normally talking about in enforcing contracts is the prior to close of escrow situation. But there are situations in which you have to sue on afterwards, or you have to enforce your remedies after a sale occurs. And again, we have to follow the notice provision. We have to follow the cure provision, which there isn't really going to be much of a cure. And then we have to follow whether the contract calls for some form of alternative dispute resolution, whether that being mediation or arbitration, or whether I can just jump to litigation. Okay. So again, that's how purchase and sale agreements work. That's a lot of information. I have a flow chart if you want it, but that's how sellers can enforce their rights. That's how buyers can enforce their rights. Now, let's talk about the second type of commercial real estate contracts that we see, which are loan contracts or loan agreements or loan documents. Okay. We have deeds of trust, we have notes, promissory notes, we have guarantees, and then we have environmental indemnity agreements. The deed of trust is security that your buyer is going to pay the loan. We have a promissory note, which is the promise to pay. I promise to pay such and such a lender on such and such a dates. And if I don't, then they can enforce that deed of trust. Okay. Then they can enforce the note. Similarly, we have commercial guarantees or loan guarantees, which are the obligation of a third party to guarantee the payment by the borrower of the note. Okay. So there are 3 primary rights that a lender has in Arizona to enforce a deed of trust. They can foreclose, they can sue for breach of the contract, breach of the note, and they can seek the appointment of a receiver. Okay, let's back up a little bit. So we're talking about situations in which a lender in Arizona can enforce loan documents, right? The first step, the first option they have, they can conduct a foreclosure. There are 2 ways you can foreclose in Arizona: trustee sale or judicially by filing a court action. They can also separately sue for breaching the note. You didn't pay your payment, you didn't make your payment, I'm now suing you for breaching the note. Okay, pretty straightforward. It's a lawsuit. They can also seek what's called the appointment of a receiver. If the lender wants to take back the property, if the lender or doesn't want to take back the property, either way, they can seek the appointment of a receiver, which is a third party to come in and manage the property because you as the borrower or your borrower couldn't do it themselves. And so the receiver is in there collecting rent payments, managing the property, maintaining the property until such time as the foreclosure happens, until such time as the breach of contract claim is done. So those are the 3 primary remedies. Those are the 3 primary ways a lender in Arizona can enforce those 3 documents. Okay. And that's really it. Now, again, in the loan situation, you've got to give notice, and you've got to give an opportunity to cure. Usually those are very short time periods, 5, 10, 15, 20 days. That's it. Okay. And so we see certain situations in loan documents where there are monetary breaches and non-monetary breaches. And so the most common breach of a loan document is usually a monetary breach, meaning you didn't make your payment. And that usually comes with a 5 or 10 day grace period. If you don't pay beyond that, if you haven't paid beyond the notice and cure period, then the foreclosure or those other 2 rights that a lender has are usually going to be enforced. There are also non-monetary defaults: failure to provide insurance, failure to stay open during certain hours, change in your business structure. Those can also lead to enforcement rights by a lender. Okay, but you're going to get notice and an opportunity to cure. When it comes to a borrower, now, so those are the lender's rights, pretty basic: foreclosure, sue for breach, appointment of a receiver. You have to give notice. You have to give an opportunity to cure. That's really it. Now, what about a borrower's rights to enforce the contract against a lender? Well, those are almost non-existent. There are almost no rights that a borrower has. The loan documents are set up and they basically say, look, you've accepted this $1 million loan. I've given you my loan. I've given you the funds. Now you just have to pay me. And so they got the money, and therefore they now have an obligation to pay it back. The only real remedy that a borrower has against a lender is to seek some sort of actions, is to file a court action for what's called declaratory relief. I want this lender to be held in breach because I didn't get all of the funds that I thought I was going to get. Or the lender promised me that I'd be paying such and such a rate, but now I'm paying a much higher rate. Or the lender told me that they were going to be the ones who were going to procure insurance, but now they're making me do that. So those types of situations are very, very rare. Okay. So borrower enforcement rights against the lender, almost non-existent, particularly in the commercial space. Okay. So again, we've talked about purchase and sale agreements. We're going to talk about 3 different types of commercial agreements. First one we talked about was purchase and sale agreements. And we talked about the seller remedies and how the seller goes about enforcing the contract. And we talked about the buyer remedies and how the buyer goes about enforcing those contracts. Second type of commercial real estate contract that we talk about were loan agreements. Okay. We talked about deeds of trust, notes, commercial guarantees. And we talked about how lenders really have 3 rights. They have the right to foreclose, they have the right to sue for breach, and they have the right to seek the appointment of a receiver. And we also talk now about how borrowers really don't have any enforcement rights, except perhaps to seek some sort of declaratory relief. Now, the third type of commercial real estate contract that we see when we're talking about rights are leases, commercial leases, right? And we have different types of commercial leases that we use. We have triple net or net leases, and we have gross leases, and each come with different responsibilities for the landlord, each come with different responsibilities for the tenant. Well, what are typically the landlord's rights if there's a breach by the tenant of some of those responsibilities? Okay, again, we're looking at the contract, right? If there's the non-payment of rent, if the tenant says, I'm not paying you or I can't pay you, well, there's usually a notice and a cure period. If the non-payment is not fixed by a certain date, well, then there's 2 things we can really do. We can exercise our eviction rights, or we can do what's called a commercial lockout. Okay, those are, and then we sue for damages, right? There's also non-monetary breaches, like the failure to maintain the building, the failure to have the correct or to maintain the correct hours, failure to provide proof of insurance, right? And so those are, so we have monetary breaches, which are non-payment breaches. We have non-monetary breaches, which are sorts of these other things. And each comes with a different time period to cure that default. Okay. And if it's not cured, then we have the right to do a lockout, but then we have the right to do an eviction action, or then we have the right to sue. Okay. What we're talking about now are landlord's remedies, right? A common question that comes up, because there's sometimes a gap, there's sometimes some missing language in commercial real estate leases. What if there is no opportunity to cure? Okay, what if there's nothing in the lease that says, hey, I have to give this tenant a certain amount of time to cure their monetary default? I have to give them 5 days, 10 days. What if there's nothing in there? Well, can I, as a landlord, lock somebody out the minute they miss their first payment? And the answer is yes. Okay. Unlike in the residential context where we have this statute that says you have to give 5 days or a certain amount of time, in the commercial setting, the minute the tenant stops making their payment or misses a payment, the landlord can lock out as soon as possible. Okay. Again, that's assuming there is no notice and cure period that's provided in there, which some commercial leases just don't have. And so common question from landlords is, when can I do a lockout? The answer is right away. There's no statutory obligation to provide notice and cure. It all boils down to what's in the contract. If there's nothing in the contract, boom, you can get them. Okay. Now, there's also other remedies for the non-payment of a lease by a landlord, and that's basically to sue under the guarantee, to sue for breach of the lease. Okay. What are the tenant's remedies? So those are the landlord's remedies. That's how the landlord goes about enforcing these contracts. What are the tenant's remedies? Again, If there are tenants remedies, those are going to be spelled out in the contract. You must usually give notice and an opportunity for the landlord to cure their default. Okay. Once notice and an opportunity to cure is given, well, then guess what? The tenant can do. The tenant's rights, the tenant's remedies are to leave. They can engage in self-help and then offset the rent, or they can separately sue themselves. They can sue the landlord for breach themselves. Okay. And so that's really it. We look at the contract for all of these situations. We have to look at each remedies, each of the parties, and see what each of their remedies are. And then we have to look at notice. We have to look at opportunities to cure, and then we have to look at what can be done next. Do we have to go to mediation, arbitration, or can we go to litigation? In the leasing context, again, there's commonly a shortfall in the document that does not provide any sort of notice and cure period if there's a non-payment of rent. And if that happens, then you can lock out immediately, unlike in the residential context. Okay, so I have a flow chart with all of these rights and remedies. If anybody wants that, looks like I've gotten some requests in the chat already for those, and I'll make sure those come out. Now, there's a couple of other remedies. These are sort of miscellaneous that people ask me about whenever we're enforcing somebody's rights under a commercial real estate contract. First is, well, what about attorney's fees? I'm going to spend $5,000 or $10,000 with you, Patrick. I want to be able to collect that back. And the answer is usually yes. There's a question here. What if the landlord does not perform with an air conditioning unit? Now, that's a big deal these days, Sylvia, particularly in mid-July in Arizona. It all depends on what the contract says. It depends on the type of notice that has to be provided. But usually, if it's blank, if there is no, if it doesn't address anything, then usually what has to happen is that the tenant has to engage in some form of self-help. They have to go fix the issue themselves and then seek to offset that from the rent if it's not already addressed in the contract. So sometimes you'll have to look to see, there'll be a section that says landlord's breach or tenant's rights or tenant's remedies. So look to that first, and then if there's nothing in there and the landlord has an obligation under the lease, so we have to look at also the obligation. That's why I brought up the types of leases, because in some leases it may fully be 100% the tenant's obligation. It may not even be a landlord obligation, and so then the question, becomes, well, whose obligation is it under the lease? So we have to look at that first as well. So it's not always the obligation of the landlord to fix the air conditioning unit. It depends on what the parties agree to in the lease in the first place. Okay, but if the landlord is obligated, let's assume that the lease says that the landlord's obligated and the landlord is just refusing, even after you've given them notice, given them a right to cure, then it becomes a self-help issue, and usually you can offset rent if you've had to go and spend money by hiring an AC contractor to do the work. Now, what you're going to want in that situation is some AC kind of expert or contractor to outline every single thing they've done and the issue that they encountered upon entering the property. Okay, so hopefully that's helpful. Now we're talking about some other remedies as well. So sometimes, or many times, people ask me, like I said, well, how do I recoup my attorney's fees? Well, we look to the contract and then we look to Arizona statute on that. Okay, in many instances, most of the contracts that we use, purchase and sale agreement, loan documents, leases, spell out who is entitled to an award of attorney's fees if they have to go and enforce their rights. Okay, if that's not in the contract that you're using, okay, you still have the right to seek attorney's fees under Arizona statute. We have a statute that's ARS 12-34101 that basically says, in a contested contract issue, in a contested action arising out of a real estate contract or any contract, the prevailing party is entitled to an award of their attorney's fees. Okay, so we look to the contract itself, and then we look to the statute to see if this is helpful to us. Okay, now this provision or this statute exists to dissuade parties from fighting or continuing a fight over a contract. Okay, or to ensure that the fight is really a legit one. Because if I'm using a contract just to harass you and there's no real legal issue here, well, then the court is going to award you your attorney's fees for having to deal with me. And so that dissuades some parties from getting in fights. Okay, so there's an attorney's fees remedy in many of these contracts. Some people always also ask me, well, what about punitive damages? I want this landlord to suffer. I want this tenant to suffer. I want, I want there to be some blood here because of what I've had to suffer in dealing with you. Punitive damages are almost never awarded in real estate, particularly in commercial real estate deals. Now, unless there's some major misrepresentation, you're not going to get punitive damages. So I would consider that a non-issue. So hopefully you'll get attorney's fees if you're on the winning side, but you'll almost never get punitive damages. So somebody put in the chat, what are the rules for rent increases for commercial contracts? Again, that's usually going to be spelled out by the contract itself. And so it'll usually say, well, we're going to use CPI, which hopefully nobody's using CPI right now because the consumer price index is usually pegged off of inflation, and inflation's super high, so rents are going to go up. So if I'm representing a tenant, I'm going to say, look, I want a hard line increase year over year. We're not going to peg it off of some index that makes it much more difficult for me to figure out what my rent's going to be, and or make there's a fight. But usually it's going to be spelled out in the lease agreement itself. And if it's not, well, then unfortunately the landlord has pretty free will to increase rent if it's in a renewal period. So if the lease is expired or we're going into a renewal period and the landlord just says, I'm going to double your rent, they can probably do that unless the contract says that they can't, unless there's something in there in a renewal clause that says, well, we're going to peg it off of somebody's appraisal, we're going to peg it off of some other number, then they can pretty much do what they want, unfortunately. Fortunately or unfortunately, I should say. Now, so those are largely the remedies that we've talked about. There's a lot of them. Like I said, if anybody wants, some language here, we'll get that to you. I'll put my information in the chat. So some people always, usually ask me, well, what about defenses? Like, what if I'm on, the not so good side of this? What if somebody's trying to enforce a contract against me, whether it's a purchase and sale agreement, whether it's a loan document, or whether it's a lease? What are my defenses here? Do I have any? Well, I've listed out about 10 that you can usually assert. Okay. One of which is prior payment. Hey, I already paid you this amount, and here's the check. You can't enforce this against me. The fact that you didn't cash the check doesn't mean I didn't make the payment, and so there's a prior payment defense. Sometimes we see situations where there's an allegation that somebody has violated the confidentiality clause. So sometimes there's confidentiality clauses in leases and purchase and sale agreements that basically, the seller doesn't want you. You might go into the seller's property and learn a bunch of stuff about how they obtain clients, or there's a confidentiality clause about how much you're paying versus how much somebody else is paying in rent. And so, the landlord sues and says, well, you violated the confidentiality clause. I was giving you a sweetheart of a deal. You went and told other people, you violated the confidentiality clause. Well, the defense to that is the information was available through public means. Okay. So sometimes we can use that as a defense. Well, hey, this was public information. It was out there on the internet. And so that's my defense here. The other defense that sometimes people use, it's called the unclean hands defense, kind of a funny word for basically saying the other side breached first. So let's say that, your landlord, you didn't pay your landlord because, because he or she was in breach in the first place. They had not fixed the air conditioning unit as obligated under the contract. That's the unclean hands. You can't sue me because you've got unclean hands. Your hands are unclean because you breached first. You did something to me that caused me to breach. Okay. Or the fourth defense that we usually see is that the defense is that the breach is non-material. So you can't sue me for something that is immaterial. That's a minor breach. Well, I provided you with this insurance. I'm giving you an example here. I provided you with proof of insurance, and it was $10 less than what was required under the lease. That's probably an immaterial breach. So you can't really sue for that. So the argument is this is a non-material breach. It's so unimportant in the overall scheme of things that that I have a defense that says you can't sue me for this. Same thing. Another defense is the course of conduct. Okay. This one comes up a lot of times in the commercial leasing space. Okay. We have this course of conduct. You let me pay by the 15th of every single month. Well, this month it's a problem. Well, wait a minute. We've got this prior course of conduct that says, hey, I had in my mind that the 15th wasn't a problem because you've continued to allow me to do this. And so if you're a landlord and you're allowing people to make their payments late on a consistent basis, you need to make it clear by sending notice to a tenant or notice to the other parties, hey, the fact that I did it once isn't setting any sort of course of conduct. It doesn't mean I'm going to do it again. Okay. There's also this estoppel argument, which is very similar to a course of conduct. Estoppel meaning ESTOPPEL. That's how you spell it. It's a legal concept that basically means, hey, my performance is excused because your actions or inactions made me think that you wouldn't enforce this against me. You collected rent payments. Yes, the lease says you could collect rent payments, or I had to make the payment to you personally, but you were collecting them when I would Zelle them to you. And now this isn't good enough. Well, you're stopped from saying it's not good enough. Okay. There's also a waiver defense, like you've waived your right to pursue this against me because of your actions. There's the defense of improper notice, which is something that we talked about. The big defense in the leasing concept is failure to mitigate. So let's say that I breach my lease. I've got 5 years left. You want to sue me for the remaining 5 years on my lease. Well, you have an affirmative obligation as the landlord to go out and find somebody else to take over my space. You have an affirmative obligation to mitigate the damages that I've caused. You can't sue me for everything unless you go and prove that you could not mitigate because there were no other tenants that would take this type of space. Okay. The 10th defense is the 10th or so defense that we typically see is the failure to use alternative dispute resolutions contained in the contract. So meaning, you jumped to litigation, but you had it first to give me notice and an opportunity to cure. You jumped to arbitration, but first we had to mediate and you didn't follow the contract. Okay. So those are about the 10 defenses that, have some merit in some instances that we typically see. But that's enforcement in a nutshell. I know that's a lot of information for 45 minutes. I do have, spreadsheets and language that I'm happy to get to you guys. It looks like some of you wanted. I'm going to put my contact information in the chat so you guys can, send me what you want and I can get it to you. Does anybody have any questions? I usually reserve 10 to 15 minutes or so for questions. I don't know if anybody has any, but happy to answer those if I can.
I got a quick question.
Sure.
How come there's not a lot of statutes for commercial? Because I heard that you said there wasn't as much.
Yeah, and there's not. And I think that the legislature and the courts have always said, well, commercial clients are more, or commercial parties are more sophisticated. They're businesses. They've done this before. They don't need the same protections that, Joe Q Public needs. And so therefore, we're just not going to create a lot of statutes for them. Okay. We're going to allow their contracts to prevail. And that's largely been true. And normally we have more equal bargaining power between a buyer and a seller, or a landlord and a tenant. We have more sophisticated parties. We have more bargaining power. And so, that's usually why we don't see these kind of consumer protection statutes that we see in the residential context. For instance, in the residential context, we don't want to just kick people out of their homes. That's probably not a good idea. And so that's why we have a 5-day or a 10-day notice required, no matter what the lease says. But in the commercial context, the courts, it's not somebody's home, it's somebody's business. So I guess it's a little less significant, a little less important perhaps. And so that's largely why we don't. I think it's because the level of sophistication and the level of bargaining power is a little bit more equal.
Okay, thank you. That's
a great question. So Pepper asks, would you recommend an LOI before a purchase contract? I would. LOIs in Arizona are usually non-binding, okay? And usually you want them to be non-binding. So LOI is a letter of intent, or you use a term sheet, which outlines the basic terms of the agreement. The reason, Pepper, you want that, or the reason I recommend those, is because it really limits the back and forth. Frankly, if you're using an attorney and you're having an attorney either review a contract or draft a contract for either the seller or the buyer or the landlord or the tenant, we want to see an LOI, because the first step that I take is to determine whether all of the items that are important to the parties as outlined in the LOI have actually made their way into the agreement. And so my first job in seeing a purchase and sale agreement is to confirm that the LOI terms are in those documents that I'm seeing, that I'm working on. And so that to me is very, very important. So to me, yes, I would definitely like to see an LOI. Again, they're usually held to be non-binding. You usually want them to be non-binding, but I like them. So you said that you do them for all your leases, but not one for your purchase and sale agreements. I can get you a sample letter of intent. Just shoot me an email after this. I'll get you a copy of one that may be helpful. But I use them in all situations. Even in the loan document set, when we were talking about enforcement of loan documents, we don't call them LOIs there. We call them term sheets. So I just need to know what the business terms are, because that's the first thing that I'm going to make sure. If I'm representing a buyer or seller, I'm going to make sure that those business terms have made their way into that document, because if not, then we got a big problem. How do you make commissions binding? That one's tough, Lisa. You may want to talk to the Association of Realtors on that one, to make a better agreement or something like that. But to make a commission binding, you have to have a strong listing agreement. You have to have a strong, well, you got to make sure that you have all of your documents in place when it comes to your listing or leasing agreements. But I don't know the answer to that question. I don't know that I can answer that one, Lisa. I wish I could make those more binding for you guys, but I just can't. Let's see. I think that's all the questions that I've. Oh, do we use California's CAR contracts? Looks like Ed Long sent that one out. I've never used. I don't use them. I use either the Arizona Association of Realtors form or the AIR form when it comes to real estate contracts, commercial real estate contracts. So I don't use the California specific ones. I use the AIR or even the AAR ones. If you guys need sample contracts, let me know. I can get you something, but let me know which side of the deal you want, whether it's a seller or buyer, a landlord or tenant, because I have language in each one of those that's swayed one way or the other.
So Patrick, you are a commercial real estate attorney?
Yes.
And then, so is it best just to have somebody like you just write the whole contract from scratch, or you take that one and modify it appropriately?
What we usually do are we kind of partner with brokers, and we have them draft it and then we modify it. And that's usually going to be a little bit less expensive. Obviously, if you want to take any liability out, agents that want to take liability or brokers that want to take liability out of their hands, they give it to us to draft the entire thing. Now we're still going to want an LOI that the agents or brokers have negotiated, but yeah, it really depends on the whether your client wants to spend the money in having an attorney draft stuff or not, or review stuff. But usually when it comes to liability, if we're drafting all of it and we're responsible for all of it, then the broker has no responsibility, or much less responsibility. And so some brokers like to do that.
Yeah, I thought, I think it was the EXP commercial broker. I'm with EXP that said that, I don't know, they don't like the Arizona contracts. They actually use the CAR, I think it is, from California.
You can, but you're going to want to make sure that you've modified it. I mean, look, it's a contract, and so you can modify it all you want. And if you're modifying it and you're eliminating the fact that California law is governing, then that's fine, because again, it's a contract, and if the parties agree to it, that's fine. I mean, I've seen contracts from all over the United States. As long as you're using the governing law as Arizona, then I'm good with that.
Sounds like it'd be pretty dangerous to not have somebody like you crank out the contract or modify it, correctly. And is there a minimum dollar amount on the property, like maybe a 4-bedroom apartment complex? It's just kind of treated residential, but like when you get up, where do we want to really look at?
Well, I look at it, I think you always want to have a fresh set of eyes looking at it. And there are different ways that I work through those. So sometimes if it's a full-on negotiation that somebody wants me to do, they just want me to step in and do everything. Well, yeah, you're going to spend a lot more. Or the way I do it, and I propose it to people, is I say, look, what I'll do is I'll give you the 10 most important things that you should negotiate, or your broker should negotiate on their own, to get you into a little bit better spot. And that's going to be, $1,500, $2,000 to do something like that. Whereas a full-on lease negotiation or full-on purchase and sale agreement, markup, that can run $5,000 pretty quickly. But if it's more of a, hey, I just need a high level look because this property isn't super expensive, I don't want to have a bunch of due diligence costs. I don't want to sink a bunch of money into it beforehand. It's, hey, can you give me the top 10 things I need to be concerned about in this document? And then I'll go and negotiate them if I can. And that's much less expensive that way.
I was gonna ask you about some pricing samples. $5,000 doesn't sound too bad for going a little bit deep. I didn't know if we were 5,000, tens or 20s of thousands.
Well, I mean, look, I've spent, on some of these $100 million deals, you easily spend $50,000 in attorney's fees going back and forth because there's a lot more at risk. But in it, something that's, if we're buying a strip mall here, we're buying a out parcel, we're buying the 4-bedroom or the four unit complex. Yeah, you're $2,500, $5,000 at the most. So Pepper asks, what law firm are you affiliated with, or are you an individual? I own my own law firm. It's McQueen and Gottlieb. I'm the McQueen of that outfit. Well, if there's nothing else, I've left my contact information in the thread. I'll put it in here one more time, and then we can sign off.